over the vetting of judges and magistrates after the vetting board has stated categorically that they do not recognize the jurisdiction of the courts which suspended the vetting process last week.
Well, the vetting board says they are protected by the Constitution against such court action, while the petitioners who successfully sought the court order also now argue that the board is in office and constitutionally. KTN's Notiano with the details.
The Judges and Magistrates Vetting Board only stopped short of saying they will defy last week's court order suspending the vetting process for 14 days.
We are looking at all possible options, and the options are numerous, and we have to give it very considered consideration as to how we wish to approach the matter. But you can be assured that the vetting process will resume very, very soon.
It is unclear what the consequences would be if the vetting board indeed goes ahead to defy the order.
I met with the Honorable the Chief Justice this morning. He indicated that he understood the concerns of the board and reaffirmed his frequently stated position that he was anxious to see that the vetting process is completed as soon as possible.
The Center for Human Rights and Democracy had filed a petition in September against the vetting board after the board recommended the sacking of High Court judges Mohammed Ibrahim and Rosalie Nambuye. The petitioners argued that since the mandate of the board expired on the 23rd of May this year, any decision made after that date, including the decision on Judge Ibrahim and Justice Nambuye, are illegal, null and void. In July, the term of the board was extended by Parliament to February 28, 2013 after an amendment of the Vetting Act. Last week, 2 out of the 3 judges ordered the suspension of the vetting process as they made a request for a 5-judge bench to be formed to hear the matter instead of just 3 judges. But the vetting board has taken issue with the fact that one of the judges, Justice Mohammed Warsame, who gave the order, is also facing the vetting process soon.
In the present matter, a judge who is himself due to be interviewed by the board on the 16th of October 2012 issued a stay which purported to paralyze all operations of the boards for 14 days.
The vetting board has now announced what was essentially an intention to ignore the order. They cite section 23(2) of the 6th schedule of the Constitution, which states that a removal or a process leading to the removal of a judge from office by virtue of the vetting legislation shall not be subject to question by any court.
The people who very clearly stated that they had no objection to the particular members interviewing them. It is only after the decision those that were found unsuitable are now finding ways and means of destroying or trying to damage the credibility of the board. And fortunately, I can say that this attempt has not succeeded.
Now, KTN Prime.